This section of the presentation covers the open meeting law's requirements for executive sessions. Please note that this presentation is current as of March 2018. Please check with the Attorney General's office to ensure that a more recent presentation has not been published. You can do so by visiting the Attorney General's open meeting law website at www.mass.gov/AGO/open meeting. The open meeting law allows public bodies to conduct closed or executive session meetings in certain circumstances. There are 10 purposes for executive session, and a public body may only enter executive session for one of those 10 purposes. Before entering executive session, there are a number of procedural steps a public body must take. Failure to take these steps could result in nullification of any action taken during the executive session. A public body must convene an open session prior to going into executive session. It is not appropriate, for example, for a public body to hold an executive session at 6:30 p.m. and then hold its open meeting at 7 p.m. The public body must convene an open public meeting first and then follow the procedures in public to enter executive session. When entering executive session, the chair must publicly state the purpose or purposes for the executive session. The chair must provide as much detail as possible about the reason for the executive session without compromising the purpose for confidentiality. This level of detail about the discussion topic should also be included in the meeting notice, provided the executive session was reasonably anticipated by the chair 48 hours before the meeting. While we generally defer to public bodies' assessment of whether the inclusion of specific details would compromise the purpose for an executive session, a public body must be able to demonstrate a reasonable basis for that claim if challenged. The public body must conduct a roll call vote to enter executive session and obtain a majority vote of the members. Before entering executive session, the chair must inform the public whether the body will reconvene an open session after the executive session or if it will adjourn from the executive session. At the start of the executive session, if any members of the public body are participating remotely, they must state for the record that no other person is present at the remote location unless approved by the body. During the executive session, the public body must maintain minutes of the meeting and retain any documents used by the public body. This is particularly important because, since these discussions occur outside of public view, the minutes are the only way the public knows what was discussed. It is important that the executive session remain focused on only those matters for which the executive session was lawfully called. If the executive session was called to discuss litigation, for instance, it is not appropriate to discuss other items such as contracts, even if the discussion would have been appropriate for executive session had the topic been announced. The chair must moderate the discussion and keep members from straying to topics that were not announced or are not appropriate for the executive session. Finally, to create the clearest possible record, all votes taken during executive sessions must be recorded by roll call and included in the minutes. Purpose 1 allows a public body to enter executive session to discuss the reputation, character, physical condition, or mental health rather than professional competence of an individual, or to discuss the discipline or dismissal of, or complaints or charges brought against a public officer, employee, staff member, or individual. A public body may not use Purpose 1 to discuss the professional competence of an individual. Employee evaluations and annual reviews must be conducted in open session. Discussions of professional competence can only occur in executive session if they are directly related to a complaint against or discipline of an individual. If a public body enters executive session under Purpose 1, the public body must afford the individual being discussed certain rights. Failure to do so could result in nullification of any action taken by the public body during the executive session and possible reinstatement of a dismissed employee. The public body must notify the person being discussed in writing at least 48 hours before the proposed executive session. The individual has the right to request that the discussion be conducted in open session, and the public body cannot deny this request. The individual also has a right to be present at the executive session during deliberations that involve him or her. The individual has a right to have counsel or another representative present for the purpose of advising the individual, but not for the purpose of active participation. The individual has a right to speak on his or her own behalf during the session. Finally, the individual has the right to create an independent record of the session through audio recording or transcription at his or her own expense. Note that a public body is not required to discuss any topic in executive session. Thus, if a public body chooses to discuss a topic in the open that may be appropriate for executive session under Purpose 1, it may do so, and the subject of the discussion cannot force the body to discuss the subject behind closed doors. Purpose 2 allows a public body to enter executive session to conduct strategy sessions in preparation for negotiations with non-union personnel or to conduct collective bargaining sessions or contract negotiations with non-union personnel. When discussing the contract of non-union personnel, there is a presumption that professional competence of the individual has already been discussed in open session. It is not appropriate to use this executive session purpose to perform an annual review of an employee's performance if one has not already occurred in open session. However, how a performance evaluation affects a contract negotiation can be an appropriate part of the executive session discussion. While a public body may agree on terms with individual non-union personnel in executive session, the final vote to execute such agreements must be taken by the public body in open session. Generally, a public body must identify the specific non-union personnel or collective bargaining unit with whom it is negotiating before entering into executive session under Purpose 2. A public body may withhold the identity of the non-union personnel or bargaining unit if publicly disclosing that information would compromise the purpose for which the executive session was called. Public bodies must be able to demonstrate a reasonable basis for this claim if challenged. Purpose 3 allows a public body to enter executive session to discuss strategy with respect to collective bargaining or litigation if an open meeting may have a detrimental effect on the bargaining or litigating position of the public body and the chair so declares. The chair must declare publicly before entering executive session that deliberating in open session would have a detrimental effect on the public body's bargaining or litigating position. When entering executive session to discuss strategy with respect to litigation, the litigation must be pending in court or imminently threatened or demonstrably likely. It is not appropriate to enter executive session simply because a party has an attorney or has a right to appeal a decision by the public body. In contrast to non-union employee negotiations, a public body may approve final terms and execute a collective bargaining agreement in executive session. However, once a public body has approved the collective bargaining agreement, the public body should disclose the agreement in open session following the agreement's execution. Generally, a public body must identify the collective bargaining unit with which it is negotiating or the litigation matter it is discussing before entering into executive session under Purpose 3. A public body may withhold the identity of the collective bargaining unit or the name of the litigation matter if publicly disclosing that information would compromise the purpose for which the executive session was called. Purpose 4 allows a public body to enter executive session to discuss deployment of security personnel or devices. Examples include discussing security detail at an event or parade route or discussing the location of security cameras. This purpose may not be used to discuss police contracts or employment in executive session. Purpose 5 allows a public body to discuss matters of criminal misconduct in executive session and includes the discussion of referrals to law enforcement authorities. Unlike Purpose 1, this executive session purpose does not require that the public body inform the person who is the subject of the discussion or state the individual's name in the meeting notice. Purpose 6 allows a public body to enter executive session to consider the purchase, exchange, lease, or value of real property if the chair declares that an open meeting may have a detrimental effect on the negotiating position of the public body. The public body must be considering the purchase, sale, lease, or value of real estate. General discussions of land use are not appropriate under this executive session purpose. The chair must also declare publicly before entering executive session that deliberating during an open session would have a detrimental effect on the public body's negotiating position. Generally, the body should identify the specific piece of property it plans to discuss before entering executive session, unless disclosure of this information would compromise the purpose for secrecy. Purpose 7 allows a public body to enter executive session to comply with or act under the authority of any general or special law or federal grant and aid requirements. The public body must cite the specific statute or federal grant and aid requirement that requires confidentiality or a closed session. For example, the law requiring the abatement applications be kept confidential. We strongly recommend consulting with counsel before entering executive session under this purpose, as it may require legal determination. Prior to entering into executive session, the public body should disclose the specific statute that requires confidentiality, unless public disclosure would compromise the purpose for secrecy. Purpose 8 allows a public body to enter executive session to consider or interview applicants for employment or appointment by a preliminary screening committee if the chair declares that an open meeting will have a detrimental effect in obtaining qualified applicants, provided, however, that this clause shall not apply to any meeting, including meetings of preliminary screening committees, to consider and interview applicants who have passed a prior preliminary screening. A preliminary screening committee need not include any members of the parent body, but if it does, it must consist of less than a quorum of the parent public body. People who are not members of the parent public body may also be members. A preliminary screening may include resume review and more than one round of interviews resulting in the recommendation of 2 or more finalists to the parent body. Once there are finalists, however, all additional interviews must be conducted in open session. Before entering executive session under this purpose, the chair must declare that an open meeting will have a detrimental effect in obtaining qualified applicants. Purpose 9 allows a public body to enter executive session to confer with a mediator on a litigation or other decision during a formal mediation process. Note, though, that the decision to participate in mediation must be made in an open session meeting. The last purpose, Purpose 10, applies to a select few public bodies. It allows them to enter executive session to discuss trade secrets in the course of activities conducted by a public body as an energy supplier. These are public bodies organized to supply energy pursuant to specific state laws.